Well, good morning. I'm David McCaleb with Bankers Insurance, and with us this morning is Jamie Hasty from SESCO Management Consultants. We partnered with SESCO for many, many years, and since 1945, they provided human resource and employee relations consulting throughout the country. Welcome to our webinar on navigating and applying the Family Medical Leave Act and the Americans with Disabilities Act. This will be recorded, and I will share that recording out with everyone who's registered at the conclusion of the webinar. Also, there will be a Q&A session at the end of the webinar, but just to be safe, go ahead and place, whenever you think of them, go ahead and place your questions in the Q&A chat feature. Excuse me, the chat feature is actually disabled, but there's a Q&A feature. Place them there in the Q&A feature as you think of them, and we'll try to hit them along the way as we go along the way as well. And with that, I'm going to turn this over to Jamie Hasty, Vice President of SESCO Management Consultants.
Thanks, David. Good morning, everybody. It's a pleasure to be with you. We've got some slides to go through. We're going to talk a little bit about Family Medical Leave Act and just a reminder who that applies to, how that works. Because quite frankly, I get questions on it weekly. Didn't know I had to issue it. What do I do with this person? So-and-so told me that they want the leave, but they haven't given me any medical notes, and I don't even know why they're taking the leave. So FMLA gets quite tricky, but also remember that there is quite a lot of liability associated with non-compliance of family medical leave. And then we'll roll into Americans with Disabilities Act as amended and cover that. But also we're going to cover how do the two interplay with each other. Because there is a common misconception out there that, you can treat them separately, but a lot of times what qualifies for FMLA may qualify under ADAAA depending on the severity of the situation. So they can play together nicely. They can also play together separately. But then more importantly, how does that interact with short-term disability and workers' comp and all of these other things on top of what do we do about their medical benefits? So we've got a lot to cover in roughly an hour. As David said, please use the live event Q&A. I will do my best to keep my eyes peeled on it throughout the time. And what I may do actually is check it at the end of each section and then kind of go back if needed. So feel free to use that. If you bear with me, I am going to share my screen. And David, I think that is showing, hopefully. And let's see, perfect. Okay, wonderful. So about SESCO, David was kind enough to give us a quick little intro. As a reminder, if you are a Bankers Insurance client, and your broker has enrolled you in the SESCO Bankers Partnership Program, you have some very basic free services with us. Again, that's only if your banker or your rep has enrolled you. If you're not sure, reach out to your rep and we can certainly talk about that and how to gain access to SESCO. So let's talk about family medical leave. Family Medical Leave Act applies to employers who have 50 or more employees during 20 or more calendar work weeks in the current or preceding year. And the other piece about that is that the work weeks need not be consecutive. So if you're an organization who has a lot of seasonal employees, has kind of gone, up to 75, then down to 35, and then back and forth, and et cetera. If you've hit 50 or more during any of the 20 calendar work weeks in the preceding year or in your current year, you're required to comply with the law. Okay. It also applies to if you've got multiple locations within a 75-mile radius, and there is in total within that radius 50 or more employees. Now, we also get a lot of questions about, well, 50 employees, does that include part-time? Yes, you're physically talking about 50 heads, 50 bodies. Doesn't matter whether they're full or part-time, it's 50 actual individuals. Also, as all employers, well, I shouldn't say all, most employers are, you're engaging in commerce. So that's an easy check. and have employees on paid or unpaid leave as long as there is a reasonable expectation that they return to active employment. So again, with family medical leave, there has to be an intent to return to work. If somebody goes out because they're having surgery, they're having a baby, or an immediate family member is injured or sick and they need to take time off from work, there has to be the expectation and the intent that they want to return to work once that situation has been resolved. Okay, but if I say, you know what, hey, Bill Ford, who is my CEO, I'm going to have a baby, and I'm going to go out, but I don't think I'm coming back, then FMLA is not in play here because I have no intention to return. Okay, so the first piece is, are we a covered employer? And then, if we are, which employees are actually eligible? Because it's not everybody. First and foremost, I have to work for a covered employer. I have to have been employed with you all for at least 12 months. And in those 12 months, worked at least 1,250 hours. Now, vacation, personal, sick time, holidays, none of that stuff counts towards the 1,250 hours. It's 1,250 actual hours worked. Okay. So it's not just because I work for an employer who has FMLA that I'm automatically eligible to take this leave. I have to have been employed for 1 year and 1,250 hours in that 1 year. And then my request for leave must meet certain conditions underneath the law. Okay. So excuse me, you can take up to 12 weeks unpaid leave for the following reasons. For the birth of a child, for the placement of a child due to adoption or foster care, to care for a child, spouse, or parent, i.e., this is your definition of immediate family member who has a serious medical condition, or when you are unable to perform the essential functions of your job because you have your own serious health condition. And we'll talk here shortly about what defines a serious health condition. So this 12 weeks is job protected leave, meaning you can't touch me. If I go out on this leave, I'm expected to return. When I come back within the 12 weeks or immediately following the 12 weeks, I come back to the exact same everything. Same job, same title, same work group, team, same office, et cetera, same schedule. If everybody when I was out got a 3% cost of living adjustment, I should have also gotten the 3% cost of living adjustment. Okay, so it's job protected leave. We also have the ability to take FMLA up to 26 weeks unpaid leave for the following reasons. Because my immediate family member is being called to active duty, I need to spend time with them to get our household in order, whether that be securing childcare, changing bank accounts, doing visits, et cetera. I have up to 26 weeks prior to them leaving on active duty to spend with them as a service member. The second piece to the 26 weeks is because that immediate family member has returned from active duty and they are recovering from a military-related injury, and I need to be their caregiver. Okay, so that's 26 weeks unpaid job protected leave. Also, I do want to note a few years back, FMLA did make some updated definitional changes as to who is considered an eligible employee. And this is to become more in line with mainstream societal definitions of marriage and the legalization of same-sex marriage. So keep in mind when we say spouse, it includes same-sex spouses, as well as same-sex spouses in the military. The other piece that they did include was the change in eligible definition of stepchild. So if I have a couple who are a same-sex couple and or I've got a heterosexual couple who has stepchildren, et cetera, that stepchild is included in the eligibility definition of a child, regardless of whether or not I have what we refer to as in loco parentis. In loco parentis means that it's not my, I have temporary oversight, day-to-day care, financial support for this child. So, for example, if my brother, who has two beautiful little girls, was in the military and his wife was also in the military and they're both being deployed, what's he going to do with the kids? Well, he's going to allow the children to go temporarily stay with a family member, and in this case would be me as the aunt, and he would have some sort of documentation that says, I give Jamie, permission to provide, financial support and make decisions regarding the health care of the children while I'm on active duty. So I would be in loco parentis of my two nieces, even though physically they are not my children. So I hope that makes sense. So you can have a situation where somebody is in loco parentis, foster parent, another family member where that family member is truly the designated caregiver for the child. So also step parent is included there for same-sex spouses as well. So I see a lot of mistakes regarding FMLA. I get calls on it daily from everybody in all industries. And it's hard because there's a lot of documentation and steps that go along with FMLA. And it's kind of hard to keep up with it all. And in full transparency and fairness, especially if you're wearing multiple hats in the organization, or you've got a larger organization and managers don't notify you when somebody went out, it can be a struggle. So the first mistake that I see is that employers fail to have the proper documentation. First and foremost, if you are a covered employer, you are mandated under federal law to have an FMLA poster displayed in a common area along with your other federal posters. If you do not have an FMLA poster and you are over 50 employees within a 75-mile radius, you need to get that taken care of ASAP. The other piece is you need to have an FMLA policy that is in your employee handbook, okay? Please do not borrow a policy from another organization because you don't know whether that policy was compliantly written, okay? You need to have a solid FMLA policy in your employee handbook. It's also mandated underneath the regulation. You thirdly need to have appropriate requests for leave and medical certification forms. And alongside that are required written notices. So when I talk about documentation, if I'm auditing a client or if I'm dealing with a situation with the EEOC where I have to defend a charge of discrimination against an alleged violation of Family Medical Leave Act, some things that I'm going to ask the client is, number one, where's your poster? Number two, let me see your policy. Number three, send me everything that you sent in terms of written, formal documentation. And that's where they fall short. Well, it was a text message. Well, it was an email. Those things don't suffice underneath the act, okay? So if somebody has been out 3 days consecutive sick, that is a red flag to the manager or to the HR individual or to the office manager, whoever is in charge of tracking attendance for that individual. That should be a red flag that we need to start asking questions. When do you expect to come back? Are you seeing a doctor? What's going on? Now, It's a fine balance because you don't want them to tell you all about their personal medical information. But we just need to generally know, if you've been out for 3 days sick, like, when do you expect to return? Generally, within reason. The easier ones to know are, somebody's going to go out for the birth of a baby. That's an easy determination to know. Yep, that's FMLA. Or somebody has a scheduled surgery that's going to take them out for 6 weeks because of surgery and rehab, for like a knee replacement or something of that. Those are easy to determine. But nonetheless, you still have to send the first letter to the employee that says, hey, Susie, hey, Mary, hey, John, we've been notified that you're going out for an extended period of time, and it may qualify under Family Medical Leave Act. As a reminder, it's job protected leave, et cetera, et cetera. Enclosed with this letter is medical certification that needs to be completed and returned by your doctor, your treating doctor, within 15 days. Failure to get it back within 15 days may result in us denying the leave request. So that's letter number one, right? You send them the information, the doctor needs to complete it, we need to get it back, we need to review it. Letter number two is we have reviewed the medical certification and we're sending a follow-up letter to either approve the leave or deny the leave in writing. If you're approving it, you need to note, when does it start? When does it end? What their required expectations are on maintaining ongoing communication and intent and expected return to work date, as well as what their rights and responsibilities are if they're on your health insurance. Okay. They still need to pay their portion of their medical premium if they are on your medical insurance. You cannot kick them off the plan, okay, because of hours worked. If they fail to pay those premiums while they're out on leave, then we have a different conversation because we have to send a separate letter, but that's a combo for another day. So you've got the first letter that's, hey, we think this is going to qualify, get this completed, send it back, we'll look at it. Letter number two is your approval or denial. The third letter that you should send should be a week or two roughly prior to their anticipated return to work date. Hey, Mary, hey, Susie, just checking in. You're expected to return on this date. Please, as a reminder, you're going to need a clearance from your doctor to return to work. So we're going to need that documentation. Enclosed with this form is a fitness for duty return to work form. If you are not able to return, then we'll explore other options. And when I say other options, I don't necessarily mean separation of employment, okay? But they may need an additional 4 weeks off due to complications, and that's where ADAAA would come into play. So there's 3 required pieces of documentation, letter-wise, that you should be doing. And 9 times out of 10, I only see maybe 1 from companies that we're working with. And that's a huge area of liability. Again, text messages and letter or written emails are not necessarily going to suffice. Written emails are better than nothing at all. But you need to have this in paper, as well as have sent everything certified mail receipt, whether that's through the Postal Service or UPS or FedEx, whatever it is. But I want to show, if I have to defend a claim, I want to show the Department of Labor, EEOC, look, we did everything. We checked every single box in terms of compliance. So you've got those written notices. So that's the biggest mistake that I see, is that the documentation is not there. Mistake number 2, huge misconception that, and I swear I hear it at least once per week. Well, the employee didn't ask for FMLA. The employee doesn't have to ask for FMLA. It is up to you as the employer to know who is missing, who is out, how long they're going to be out, and to designate or engage in the process. Excuse me. That is why it is so important that your managers are also trained on what to look for in terms of FMLA so that they can keep you in the know. So the notice required varies depending on the need and if it's foreseeable. So when we're talking about surgeries or adoptions, births, generally speaking, those things are known about in ahead of time, and that the employee can give 30 days notice, to make sure that we get all the paperwork completed and we've got everything all squared away. But sometimes things happen. I was hospitalized because I was in a nasty car accident. Well, clearly, if I'm in the hospital, I can't request leave 30 days prior. I wasn't expecting to get in that accident. And number two, it may take me a while to get that information completed because I'm in the ICU. So, some of this is a little bit flexible, but what we don't want to have happen, and unfortunately, I see it a lot, is somebody's been out for weeks and weeks and weeks already. And then the client gets frustrated when it's 2 months behind, when the employee is 2 months behind in insurance premiums. And when I talk with them, there's no documentation. They never issued FMLA, even though it was FMLA qualifying. There was no notice to the employee that they were required to pay this. So yes, if things happen and somebody's been out for a week or two and you just found out, backdating FMLA for a short period of time is not the end of the world, but it is incredibly difficult from a consulting perspective as well as a defense perspective in the eyes of the Department of Labor to say, you didn't even issue FMLA until literally their leave was done and you want to backdate all of this. That's a harder sell, okay? So that's why it's really, really important to be in the know and stay on top of attendance and employee medical needs. Mistake number 3, the supervisor is the issue. And it's not because they are willfully trying to violate FMLA. It simply boils down to most of them don't know what they're responsible for, or they don't have enough knowledge of FMLA to know what to look for. And that's why the training is so important, because DOL has reported that the most frequent violations of FMLA are directly correlated with the supervisor's lack of knowledge about it. Okay. You all need to have in your organization a designated individual who they can refer actual and potential FMLA situations to. I don't want the supervisor getting into the medical specifics with these employees because we've got a variety of confidentiality laws that we don't want to violate. So the supervisor should know A, what to look for, but B, who do I send them to kind of take me out of the situation as a supervisor and let somebody that truly understands FMLA handle it from here. Yes, the supervisor is going to be kept in the know, but they don't need to be responsible for doing the FMLA paperwork themselves. And then I mentioned how they should be asking, 3 days out sick, when are you coming back? Are you going to go see a doctor, et cetera, et cetera. So we've got that on there. Mistake number 4, not understanding what is a serious health condition. A serious health condition is not just for birth or surgery. Obviously, those are easy ones to determine. A serious health condition is defined as an illness, injury, impairment, whether it's physical or mental, that meets any of the 3 criteria, or any 2. Let me clarify that. It's either inpatient care, which is 24 hours overnight in a hospital, or I am seeing a healthcare provider twice in a 30-day period for ongoing treatment of a health condition. That's it. That's the definition of a serious health condition. So, if I had COVID, it could qualify for FMLA, whether I was in the hospital or not just because I was quarantined. Maybe I had a nasty condition or case of it, and I was seeing my medical provider twice in a 30-day period, and they gave me antibiotics and they gave me something else because the first round didn't work. It could qualify for family medical leave. Anything that is prescription medication, therapy requiring special treatment, addiction treatment, those things do apply to FMLA. What does not apply to FMLA would be regular doctor visits, my annual checkup, my eye checkup, dental, those things aren't. Now, if I'm having dental surgery like wisdom teeth, okay, maybe. But again, you have to explore what are the facts and circumstances of that specific surgery. And if there are complications, then obviously that solidifies a little bit more. Okay, so you got to know what a serious health condition is and how it's defined. Mistake number 5 is that improper documentation. I talked about the letters. I talked about the medical certification. The law says that it's got to be completed and returned within 15 days. Now, what I will tell you is we're seeing that 15 days get pushed for a number of reasons in a practical perspective. Doctors are overwhelmed, or the nurse gets the paperwork and it sits in the doctor's inbox for 10 days and you're calling, you're like, where is it? So, yes, can we deny if they don't get it back within 15 days? But, if you haven't gotten it back within the first 10 days, just call and remind the employee, hey, we need it back. And they may tell you, I've given it to the doctor. They said they were going to complete it, etc. I haven't gotten it back. As soon as I do, I'll let you know. But I've had situations where employees have gotten it back like 45 days after we sent it. And that's not acceptable. Again, every situation is unique and we have to look at the reasonableness of how late that documentation truly is. You can always contact the medical provider yourself and send the paperwork directly to them. If you get it back and the medical certification doesn't match up with what the employee was telling you, or you're not really convinced that it's 100% accurate, you can get a second and third opinion if necessary, but that's going to be paid at the expense of the employer. Okay. So you've got the request for leave, designation letter, and the exhaustion leave letter. And as I mentioned, send everything certified mail receipt, UPS. You can send an extra copy electronic, but always put a red receipt because we always prefer hard copies. Okay. Also, on top of improper documentation, there's a common myth out there that only the doctor themselves can complete the certification. Okay, and so FMLA defines a healthcare provider. It's a doctor or anyone determined by the Secretary of Labor to be capable of providing healthcare services. So, when you get into a situation where their nurse practitioner has completed it, social worker has completed it, a physician assistant has completed it, technically an RN probably isn't going to complete it. They may fill it out and then the doctor will sign it. But, it's not necessarily worth fighting unless it was some front desk office person that completed it and they weren't supposed to. Okay. Mistake number 6 is we fail to integrate FMLA with other leaves. So I mentioned at the beginning of our time that FMLA can integrate a lot with other things. So our recommendation has always been that FMLA leave runs concurrently with any paid leave available. Okay, so if I've got 2 weeks of PTO on the books available for use and I need to go out for surgery, that is 6 weeks. My FMLA is going to start. The first 2 weeks of that will be paid, exhausting all of my paid vacation or my PTO available. But I'm still counting the first 2 weeks as FMLA leave. It's not going to count separately as vacation. Okay. And then perhaps I have short-term disability, either as a supplemental policy and or maybe the company pays for that insurance coverage, which would be incredibly kind. That short-term disability would kick in after I've exhausted all of my paid available accrued leave. Okay, so in theory, I can have somebody on FMLA running concurrent with my PTO, short-term disability, and heck, perhaps the reason why I'm on FMLA is because it was a workers' compensation situation. So you can have all of those running concurrently at the same time, okay? So it's important to know, what do we have on the books? What other benefits are available to run? And that all of the time is tracked and documented really, really well, okay? Set up a spreadsheet, set up like a handwritten tracking something, but we should be keeping track of all of that. Mistake number 7 is that the employee and the employer communications are poor. So either we're not staying in touch with the employee and we forgot and they've been out and we haven't heard from them and they were supposed to be back 2 weeks ago. I don't know what's going on. It's because you failed to stay in touch and you failed to send that check-in letter right before their leave was exhausted. It could be failure on the employee. Maybe you're doing your part and they're unresponsive. That can be incredibly frustrating as well. But to note, every single time you reach out to that employee, what day it was, how you reached out, did you leave a voicemail? Did you also send an email and a text? Save copies of those things. Perhaps I've got somebody that is not taking lump sums of time off. Maybe they're on what we refer to as intermittent FMLA, where I'm taking a day here and a day there because I've got ongoing physical therapy or migraine treatments. You know, the employee may not be notifying HR or the manager of that intermittent time or the time needed off, and that can be a struggle. And then last but not least, not notifying the employee of the benefit premium. Now, I mentioned earlier, you can't just terminate somebody from the medical plan, right? So FMLA requires that the medical benefits be maintained during the job protected leave. However, there is an out if we need it. Because the employee is still responsible for paying their portion of the premium, if they fail to pay that, you need to send them a fourth letter, a written notice that says, hey, Susie, you missed March's insurance premium payment. You've got 30 days to pay it in full, plus April's, because we're now in mid-April. So you owe for 2 months, not just one. You've got 30 days to pay both in full, or else we will terminate your health insurance. You've got to send that letter, okay? You can't terminate without sending that letter. And it's up to Susie to get that money to you. If Susie doesn't get that money to you, fair game, cut them off. And then issue COBRA, but you got to send that letter first. And mistake number 8 would be terminating immediately after FMLA. So it used to be the old sense of 12 weeks is up, they can't come back, too bad, so sad, we're separating employment. And EEOC came out many years ago, a few years ago, and they said, wait a minute here. A lot of situations that are FMLA may also qualify under Americans with Disabilities Act as amended. And you know, you need to pause and kind of look at what's going on, how much time they need, and does it qualify for ADA? And if it does, then you need to give them a reasonable accommodation, which in that instance would be an additional unpaid leave of absence. So this is where FMLA and ADA start really integrating with one another. And you want to make sure that we are engaging in that subsequent process if the person cannot physically return immediately following FMLA. Okay, so before I jump back, let's see, I'm going to do this. David, bear with me because when I share my screen, I cannot see the chat feature. There
is one question that came in,
okay.
And it says, is a fitness of duty form needed after a 12-week leave taken for the birth of a child?
Yes, you should, no matter what, always get a fitness for duty return to work clearance from a medical provider, whether it's a birth, surgery, anything. There should always be a fitness for duty return to work. That's a great question. Anything else? Any other questions on FMLA before we roll into Americans with Disabilities Act? I don't see anything, but
No, I don't know either.
I'm working through 2 screens, so I figured out how I can see it. I just gotta change my screen here for a second. Okay, perfect. So then I'm gonna go back.
Just a reminder to the participants, if you do have a question, please feel free to go ahead and place it in the live event Q&A as we go through. And if we don't get to it as we go through, we'll get to it at the end.
Yep, sounds good. And I just realized I'm pushing. Well, I'm not pushing. We've got about 20 minutes, so I'm good. Americans with Disabilities Act is a little bit more open-ended, I would say, in certain ways than family medical leave is. So ADA has been around since 1990, but then it was expanded in 2008. And there are various titles of ADA. So you've got the public side where you're dealing with public access, like accommodated bathrooms, ramps, water fountains, all of those things, braille systems, notification systems. Then you have Title I, which really applies to the employment side. And that prohibits discrimination against a qualified individual who may have a physical or mental disability. And our screening and hiring, our training, our wage payments, just general terms of employment, conditions of employment, right? And so ADA defines a basic definition of a disability as a physical or mental impairment that's going to substantially limit one or more of my major life activities. I'm going to show you what those are here in just a sec. And I may have also had a record previously of that impairment, or I've been regarded as having that impairment. So that is the definition of a disability. Now, what are major life activities? Caring for myself, seeing, hearing, eating, sleeping, walking, concentrating, communicating, speaking, all of these things. So if I have a medical condition that substantially impacts my ability to do these things, I also am going to look at, are these things required for the actual job that I'm applying for or I currently hold, and how does that hinder my ability to do the job successfully? Okay, so maybe I work in a warehouse for you, and I'm required to lift up to 50 pounds day in and day out because we're stocking shelves, or I'm loading trucks, or whatever it may be. And my physical disability, maybe I've got gout in my foot, so I can't stand for long periods of time, and I can't bend. Those things are required for the job. Okay, so we're going to have to look at the fact that this is going to qualify as Americans with Disabilities Act. And based on a medical provider certification of that condition, along with a copy of the job description and the physical, sensory, environmental requirements of the job, he's going to determine, do I need light duty work? What type of limitations or restrictions does this person have? And then we go from there. So ADA is a little bit more interactive and a little bit harder to kind of navigate than FMLA is at times. Also keep in mind that there are major life activity categories, which include all of your major bodily functions that also qualify under the Act. So there also will be impairments that always meet the definition of a disability. If I have cancer, always. Most mental health disorders, depression, bipolar, schizophrenia, stress disorders, HIV, AIDS, diabetes, epilepsy, et cetera, et cetera. All of those will always meet the definition of a disability underneath the Act. So what happens when somebody is demonstrating an inability to perform the job and we believe that it might be due to a medical condition? Or they've said, oh, gosh, I'm just really depressed. COVID's got me really depressed. Got to go talk with my doctor, et cetera. That's your red flag. That is your red flag to say, this might be ADA this may be ADA. So ADA requires that if somebody has a physical or mental disability, or we believe them to have a physical or mental disability that's impacting their ability to perform the essential functions of the job, or throughout that job application process, that we look at those essential functions. And when I say essential, I mean, why does the position exist? I want to see a job description that denotes specifically what are the essential functions of the job, not this routine, repetitive, nitpicky, 500 million bullet point stuff. Those are things that are done occasionally, once a week, what have you. No, what is the majority of the time spent in terms of essential functions of that position? Okay. I also want to know, what are the physical requirements of the job? What are the environmental exposures and requirements of the job? What are the sensory requirements, so on and so forth? Every job description that you have in your organization should have an ADAAA sheet attached to it, or an ADAAA paragraph that denotes what the requirements of the job are, okay? Because you need to be using that both in the application process, during the screening. Here's the job description. Can you perform this job with or without an accommodation? That's the only question you can ask, okay? And if that person gets hired, or I've been hired for a while and I found out, gosh, I have an autoimmune disorder, didn't know I had it, and it's been causing me to miss work a lot, and I'm making mistakes, you know, that's when we have to go back to the job description and look at what are the essential functions and how this medical condition may impact their ability to do those essential functions. And then once we get medical certification, we have to look at what modifications or adjustments that can be made for that individual so that they have the exact same privileges and equal benefits of employment, and that we are setting them up for success within that role. Okay. It's got to be the same level of treatment that we would provide other individuals who don't have a disability. So when an individual who has a disability or potential disability has requested a reasonable accommodation, that's when you send off a letter, templated letter. Hey, it's been brought to our attention that, you know, you may require a reasonable accommodation. Take this medical certification to your doctor. They need to return it, and then we're going to explore reasonable accommodations. Okay. Again, send it with a copy of the job description and the ADAAA sheet that goes along with that position. And then we have to get into an interactive process. So it's not okay for us to get this information back from the doctor and go back to Mary and say, guess what, Mary, this is what we're going to do for you. No, here's what we propose. And Mary may say, I don't really think that's going to work. And it's a back and forth. It's an interactive process. Yes, we have a little bit more leeway to say we can't do that, we can do that, but there are always ways to reasonably accommodate. A lot of times employers get themselves into hot water because they say, we don't have light duty, we don't have this, or I can't do that because the manager is refusing to look at it. Everything can be accommodated. There is no way that you can accommodate pretty much anything and everything within reason. Okay. So we have to go through that process. That is also additional documentation. There is a reasonable accommodation form that you should be using to kind of document what our proposed accommodations were, what we agreed to. Everybody signs it, so there are no questions as to what we do moving forward. As I mentioned, huge mistakes with ADAAA is just that failure to accommodate. You know, we're concerned about the employee, you know, filing a workers' comp claim, which is a valid concern. Don't get me wrong. You know, or we just dig our heels in and we don't want to accommodate, or we get tired of the accommodation. The accommodation is not to give them any sort of preferential treatment. The accommodation is intended to bring them back in line with everybody else that holds that position so that they can be just as successful as those individuals. The hard part about ADAAA is that in many ways it's a case-by-case basis, because just because somebody has diabetes, so let's just say Mary and John both have diabetes. Mary's accommodation needs based on her severity of her diabetes may be slightly different than what John's accommodations are. Maybe he only needs a little mini fridge in his work area so he can keep snacks if he thinks that his blood sugar is going to drop, whereas Mary needs additional time off or shorter work days or what have you. So as much as I preach consistency and what you do for one, you do for another, ADA has a little bit more wiggle room there for you, okay? So everything is going to be determined by the facts and circumstances of each particular case. Mistake number 10 is that the ADAAA communications aren't there. In your screening and hiring practices, along with your application of employment, you should have a notice to applicants form that basically says, if you require a reasonable accommodation through the screening and hiring practices, you need to contact this person. Your job descriptions need to have ADA information on them. You also need to make sure that your supervisor has been cautioned against getting too in-depth with personal medical conversations, okay? Similar to what we talked about with FMLA, ADA, the manager just needs to know, hey, if they start talking medical, oop, go to HR, oop, go to the office manager, whoever's in charge of handling those things, okay? And then just like with FMLA, there is documentation that is required underneath law to prove ADA. You've got a templated letter, you've got a medical certification, you've got the reasonable accommodation, interactive process forms, and you also want to send all of that certified mail receipt. Okay, so ADA often plays in with FMLA, short-term disability, workers' comp, all of these things. The biggest piece is that we want to make sure that we are engaging and communicating really well. And that we are documenting really well. And listen, we don't expect you to be experts in either one of the laws. You don't know what you don't know. And that's a beautiful part about being a client and having certain access to SESCO to call in with those questions and to utilize that. So I would remind you that if you're not sure whether your broker has enrolled you, reach out to your broker. If you are a current SESCO client on a retainer level and or a member of an association that we also retain, we're not going to enroll you in the bankers program, but because you've already got access to us. But certainly, reach out, let us know what questions you may have. We're always happy to help. And David, it looks like we've got a couple of other questions here, huh? You're muted.
Apologies.
That's okay.
You want me to read them, or can you access them?
I can see them, but yeah, you read them. I've been talking enough.
Okay. So one came in: if we terminate someone's benefits due to non-payment, how does reinstatement work when they return? Does it follow plan rules or need to be the same day they return?
Great question. So typically it's going to reinstate immediately. But I would say check with your plan provider, your carrier. Oftentimes there's specific language in your contract dealing with reinstatement. But typically, because there's no break in service, it can resume immediately. But I've seen anything and everything. So that's a great question.
Okay, well, we've got another one. It says we have an employee who has self-identified as having a condition which he has had for many years. He had a bad day and felt he needed to explain. Is the proper next steps to start a reasonable accommodation conversation?
Maybe. You know, I think you have to look at, has his work performance, attendance, quality of work, has that been impacted? Have you noticed changes in this individual? Just because somebody has self-identified as having a condition and look, I'm just having a rough day, doesn't necessarily mean that you need to immediately go into a reasonable accommodation. I would say that if the main functions of the job aren't being done, and we believe that that bad day or that condition is impacting this individual's ability to do those, then yes, let's start having a conversation. Excuse me, allergies. Oh, Virginia pollen is awful. So, but it could be a simple conversation as this. Hey, John. Hey, Susie. Hey, Mary. Hey, Mike. The other day you mentioned, you're just having a really tough time. Is there something that we as the employer can do to help you? We've noticed, you've been missing some days here and there, and that's not like you. And we want to make sure that we're doing everything that we can to set you up for success. And he may say, or she may say, yeah, I'm really struggling and I'm going to the doctor and I'll see, I'll let you know. And you're like, great, here, take this form. Or they may say, you know what, no, I'm good. I was just venting because I needed to get something off my chest. I mean, there are so many variables here in terms of how that could play out. And I think that's the hardest part about ADA. FMLA is pretty straightforward, but ADA has a lot of that gray area that can get tricky to navigate. So I wouldn't say automatically go into an accommodation, but if the performance and the attendance is an issue, then yeah, that should be kind of a trigger to you of let's see where this goes. So that's a great question.
Gotcha. All right, so do employees have to request ADA in order to start the conversation, or should the employer initiate it if we see an employee who qualifies?
So that's a great question too. So the way that the regulation is worded is that the employer knew or should have known that a disability was in play. So I've had situations where the employee never said a word to management or to HR, but the employee's friend in that same department mentioned to the manager, well, Lauren's been out because she has, anxiety and depression. Well, now you've been put on notice that Lauren has anxiety and depression. That triggers an interactive process. Okay. Again, I think you go back to what are the performance standards? What are the essential functions? Is something going on where it is a sudden inability to perform that, or their performance has dropped? And then it becomes a conversation of, hey, I've noticed this is trending. What's going on? Do you want to talk to us about it? And they may freely say, I've got this medical thing going on. And that's when you issue FMLA, possibly FMLA. That's when you go into ADA and that sort of thing. So it is a little, again, kind of gray. So yes, the employee can request it. They don't have to, but if you have knowledge of it, I've had situations where spouses or parents of the employee have notified somebody that works at the company, and that was enough. So if you have knowledge of it, regardless of where that knowledge came from, it's our responsibility to certify it first, because you don't want to accommodate without having medical certification that backs up, yeah, they've got this. Because I have also seen situations where an employee was not as honest about what the actual condition was and said, oh, I can't do this and I can't do that. And the doctor's like, it's a non-issue. Yes, they can. But you've already accommodated. So you've opened that Pandora's box. And it's very hard to take away the accommodation once it's been given. So don't ever accommodate without knowing for 100% certainty that they actually do have this condition and what the doctor says their limitations are based on that job description. So that's a great question.
And we have one more, and you may have already answered this just a few minutes ago. Is the individual is not asking for RA, reasonable accommodations, but should it be done?
Again, it goes back to performance standards.
Gotcha. And one more just came in, and it says, for FMLA non-payments that result in termination, can we reinstate if we pay the time missed after terminating?
I'm not sure I understand that question.
Yeah, for FMLA non-payments that result in termination, can we reinstate if they pay the time missed after terminating? So I think what they're saying is
backdate it after they've been terminated from the plan. Well, here's the thing. Most of you all are paying the month ahead anyway, so you've already paid their premium. You can recoup it. Now, if they're expected to return, I'm not saying that you have to terminate them from the plan. They may be only a month or two behind, but they're getting ready to come back to work. And then you can add those additional monies in and do a wage deduction authorization to recoup it over the next 3 months to where it's, so there's options there. Technically, even if I was terminated from my health plan today because of non-payment, I would still be covered through the end of the month because you've already paid for my insurance premium. You paid in March for April, typically. I'm sorry, you paid for April and March. I can't even talk today. But I didn't have enough coffee this morning, David. So there's ways around that. And I would say each situation is unique, but could you reinstate? Yes. I mean, typically it's a break in service that's less than 13 weeks. The carriers are pretty flexible right now, especially considering COVID and a number of other things. So.
Well, fantastic. That's the last of the questions, and we're near the end of our time. So I'll just go ahead and say if there are any other questions, or if you need to, if you already have a relationship with SESCO, by all means, leverage that with those questions. If not, please speak to your sales executive, and they can get things rolling and get things moving in that direction to initiate a relationship with SESCO. Thank you so much, Jamie, for taking your time. We truly appreciate it. Wonderful job. Got lots and lots of other comments that came in that were just, hey, this is really great. Thank you. So wanted to just say thanks. And we will share this video again. We'll share the video out automatically to everyone who is registered. And thank you guys so much for your attendance. Enjoy the rest of your day.
Great. Thank you so much.